Welcome to episode 2 of Arbitration Life. I am Janette Bryn.
And I'm Hana Dumas.
The BVI IAC is a proud signatory of the Campaign for Greener Arbitrations, an initiative founded in 2019 to reduce the environmental impact of international arbitrations. Through this initiative, we are committed to minimizing the environmental impact of our daily operating procedures, as well as reducing energy consumption and waste in arbitral proceedings.
And we have further cemented our commitments through the new BVI-IC arbitration rules of 2021, which include provision for the use of remote hearings and electronic filing of submissions.
During BVI Arbitration Week 2021, last November, the panel speaking on the greening of arbitration and the legal system in the Caribbean gave an insight to the pledges of the campaign and the ways in which they can be implemented, as well as what institutions, law firms, arbitration practitioners, and other hearing venues can do to minimize their effects on the environment.
Absolutely. And our guest today participated to another session during our 2021 BVI Arbitration Week, the one on advocacy on remote hearings, which was a great session. And if you missed BVI Arbitration Week last November, our sessions are now available on our YouTube channel. So Janette, shall we introduce today's guest?
Commercial arbitrator currently practicing out of arbitration chambers in Vancouver, British Columbia. He has extensive experience in domestic and international commercial arbitration cases and has acted as arbitrator in arbitrations under the AAA, ICDR, ICC, British Columbia International Commercial Arbitration Center, and UN Central rules as tribunal chair, party appointed arbitrator, and sole arbitrator. He is no stranger to the BVI as he is a board member of the BVI International Arbitration Center. Please welcome Murray Smith, QC. Well, hello, Murray, welcome.
Hi.
Hi, Murray, welcome to Arbitration Life.
Hi, Hannah, thanks for having me. Real pleasure to join you.
Yeah.
So how are things in Canada?
Things in Canada are pretty much the same as everywhere. We're all hunkered down, trying to get through this last wave. We're hoping it's the last wave, and trying to survive trucker strikes, which is now a big issue in Canada.
Oh, interesting. Yeah, but I guess it's colder in Canada than where we are.
It is definitely colder.
I just thought I'd point that out, sorry.
But I'm in Vancouver, where it's not, we don't have harsh winters at all.
It's not harsh? Oh, okay.
We have maybe one snowfall or a couple days a year. That's it.
Okay, cool. All right.
Cool. Great. Well, we hope to see you in the BVI very soon.
I'd rather be where you are, for sure.
Okay, so Murray, we wanted to ask you for our first question, how you started your career as an international arbitrator.
Well, I took a very unconventional path to international arbitration. I started out as a criminal lawyer in Vancouver and practiced for a number of years doing criminal law. The last year in my Vancouver practice, I did 3 first-degree murder cases back to back in a period of 12 months. And at the end of that, I had, I think, a slight case of PTSD. So I made a career jump and moved to the Yukon Territory. And while in the Yukon, amongst other things, I was appointed chairman of the Yukon Economic Council, and I was appointed as lead counsel in a public inquiry into downstream petroleum pricing. And that gave me an interest in both international economic issues and resource issues. So I decided to go to the London School of Economics, and I took a master's degree in international economic law. And that coincided with the introduction of the UNCITRAL model law in Canada. We opened the British Columbia International Arbitration Center in 1986. And so international arbitration was going to be the flavor of the month going forward in law practice. So the courses I took at LSE were international economic law, international law of natural resources, and my professor was Rosalind Higgins, who went on to become Chief Justice of the International Court of Justice. And I took a course called International Arbitration Law, and my professor was Martin Hunter, who wrote the book that we used as our text in the course. And my final course was international law. I forget what it was. It was about international business transactions, which was about the procedural aspects of international dispute resolution. And each of those courses had an element of arbitration law. So international economic law dealt with GATT, then the General Agreement on Tariffs and Trade, which then became the WTO. And we studied what were the dispute resolution mechanisms there in a state-to-state public international kind of law process. And in international law of natural resources, we studied what Rosalind Higgins described as the great oil arbitrations, Iran, Texaco, and Ammon Oil. And those were basically investor state type arbitration cases involving bilateral investment treaties and contracts between investors and states for the development of resources. And then finally, in international arbitration law, we studied all of the basic principles of competence, and autonomy of the parties and separation of the arbitration contract from the main contract. And so at the end of that year, I got my LLM, and Rosalind Higgins invited me to join her chambers, which was 4 Essex Court. And I did that and became a barrister, which was an interesting process because generally to become a barrister, it takes a year. You have to take the course at the Inns of Court School of Law for a year. You have to do a pupillage for a year, and you have to sit 12 dinners with your in. So I was able, luckily, to do what they call double dining. So I could combine all of my dinners and get them done in 3 months. They waived the requirement to take the Inns of Court School of Law program for a year, partly because I was teaching arbitration law at the Inns of Court School of Law at the time. And they let me do a 3-month pupillage. And at the end of that period, I was qualified as a barrister. And so I was working at 4 Essex Court then, which then became Essex Court Chambers. And I was working with Johnny Beater, who was the world's most famous international arbitration expert at the time, and was until his sad recent passing. And Johnny introduced me to everybody who was anybody in the international arbitration world, and got me to accompany him to ICA conferences. And in that way, I met just everybody that could help me in my arbitration career. At the same time, Martin Hunter, who had been my professor in the International Arbitration Law program at LSE, asked me if I would write the 2nd edition of their book, Redfern and Hunter's book. Mm-hmm. So there I was, I'm at 4 Essex Court, the leading chambers in the world in the international arbitration law context. I'm writing the leading textbook and meeting everybody who's important. And that's how I got started with my arbitration career.
That's amazing. Thank you so much for this story. It's very inspiring too.
Yeah, yeah. So
Murray, I brought a prop. Oh,
you did?
I did.
You did?
Oh my goodness.
No, you still have it.
This is my wig. That
do you ever wear it now?
that I wore when I was practicing in the English courts as a barrister.
Oh my
So
goodness.
you
How
did
cool
wear
is
it, yeah, at the time.
that? Nice. That's funny. That's cool. All right. So Maury, you've been involved in legal education programs on commercial arbitration in the US, Canada, and the Caribbean. Can you tell us more about this experience?
Yes. It all started when I worked in London with Essex Court Chamber, for Essex Court, and I remained as a door tenant with then what became Essex Court Chambers when they moved to Lincoln's Inn Fields. And I was trying to stay as involved as I could with the world of international arbitration, but I moved back to Canada after a couple of years practicing as a barrister in England, largely with my wife to start a family. And in that time frame, I also became involved as a founding member of the North American branch of the Chartered Institute of Arbitrators. And the way that we gathered members in the early days of the North American branch in the mid-1990s, and I should say that the North American branch consisted of Canada, the United States, Mexico, and in part, there were members from the Caribbean too, but there was largely the three mainland countries that were involved. And we created a number of special fellowship programs, which is the accelerated route to fellowship. And so we offered both membership programs, learning programs, and the fellowship training program across the United States, and along with J.J. Pearson, who was the true founder of the North American branch, we conducted programs all across North America, dozens of programs. And in the course of doing that, we also expanded the programs to the Caribbean and had a number of programs in Kingston, in Jamaica, in Trinidad, in BVI, St. Lucia, and so it was through the Chartered Institute, Janette, that I became familiar with and friends with many of the people in the Caribbean, including you guys.
Right. Nice. Thank you for that.
So now, Murray, what do you think makes an arbitrator a good one?
Good question. I mean, it's obviously there are many things that go into becoming what I think is a good arbitrator. The usual, you have to have the demeanor and the patience and all of the things that make someone a good listener. But I think the most important thing probably is to keep in mind at all times the gravity of the task that you take on when you take on an international arbitration case. It's a great privilege and it's a great honor to be appointed as an arbitrator in an international case, but that comes with tremendous responsibility to provide the service that the parties expect you to provide, which is to be impartial, to give a full and fair hearing to the parties, and to conduct the procedures in a manner which is rigorous enough to ensure that those elements of efficiency and cost savings and speed, which are the attributes of international arbitration, are achieved. And so it's a combination of being very, very not strict, but staying on top of the procedural aspects and giving the parties the due process that they're entitled to.
Thank you very much.
What would you say was a moment of failure that taught you the most in your career?
Failure? Me? I think that the biggest failing I would identify in myself through my career was that a tendency to become too convinced about the strength of my own case. I'm not, this is not, I don't want to confuse that with hubris. I'm not talking about hubris. I'm talking about drinking your own bathwater, essentially, that you take on a cause and you begin to believe that cause, and you are somewhat blinded to the downsides of your cause. And so I think that, if you started out, when you start out with the case, and right at the beginning, you recognize the frailties of that case. And one should probably write those frailties down right at the beginning and keep them in mind as the case unfolds. And so as I write my arguments and get more and more embedded in the case, I just begin to believe in my cause more than perhaps is beneficial, because there have been cases in my past where I probably should have settled. In one case in particular, I recall, I could have convinced my client to settle. The settlement offer was a good one, but my client was adamant to go ahead, and I should have tried harder to convince him that you could lose it all. And in that case, he lost it all, and I have a lot of regrets thereafter. So I think that's it. Is that just always be alive to that, you're not perfect, and think about the frailties of the case you're dealing with, or the position you're taking, for example, if you're an arbitrator.
Right. Very good point.
Yeah, and very good advice too. So now, Murray, as board member of the BVI International Arbitration Center, what would you say is very specific to the BVI IAC compared to other arbitral institutions?
I think that the biggest calling card that the BVI IAC has is the strength of its bench. And by that, I mean, the BVI is unique in the world in the sense of there are something like 500,000 companies registered in the BVI, and this was followed the 1997 reversion of Hong Kong to Chinese rule, and for some reason the BVI became the preferred place for registration of companies and trusts and things like that. And as a result, the BVI has developed a tremendous team of lawyers who are very knowledgeable about international law and in arbitration law in particular. And in addition to that very strong legal foundation, there is a strong bench in the BVI. The judges, who are often commercial court judges from England, are very strong supporters of international arbitration law principles and very knowledgeable about commercial matters. One of the things I learned when I practiced in England was just how good those commercial court judges are in being able to take a very complex situation, umbrella companies and trust agreements, and distill them down to the essentials and to get to the result, which is key to international arbitration maintaining its reputation for efficacy and reliability and competence in terms of getting a result that is economically just and makes good business sense. And so I think that that's the greatest thing in the BVI, is that the legal infrastructure there is tremendous. And then you combine that with the parties who want to maintain confidentiality in their proceedings can go to a place that is not someplace where there's going to be a group of reporters hanging outside the front door. And at the end of the day, if you're parties or counsel involved in an international case, what better place to go to have a 2-week hearing than the BVI? So it's going to have a great future too, I think, for all those reasons.
Definitely.
Thank you, Murray.
Now, Murray, if you had not gone into arbitration, what do you think your career path would have been, or what would you have been?
Well, my first incarnation was as a scientist. My undergraduate degree was an honors degree in biology and chemistry. And
Wow.
my career path was to have a life in science. And just in my third year of that program, I decided to write the LSAT and apply to law school and got accepted. Who knows why there were almost no scientists in my first year class at law school. Serendipitously, I ended up in law rather than science. So I don't know what I would have been, a drug salesman. Who knows?
Thank you, Murray. Now, what advice can you give to those who are just starting their career in arbitration?
That's a question that I'm asked over and over and over. I'm on the advisory committee of a Canadian initiative through the Chartered Institute of Arbitrators to create a mentorship program, which we have in play now, which tries to link up junior arbitrators with senior arbitrators to get experience. As I'm sure you know, the arbitration business is the old chicken and egg story. You can't be an arbitrator until you've been an arbitrator. And so what I recommend two things, because I have this conversation with juniors on a frequent basis. So I recommend two things. One is that you have to go to these conferences because you have to be known in the business. And the reason for that is that, based on my experience as counsel in arbitrations, and also in my role as a party appointed arbitrator looking for a chair for a tribunal, I know what the process is for selecting an arbitrator. And what often it comes down to is that you get on the phone either with the other lawyer or with the other arbitrator, and you say, okay, we need a chair. Who do we know? And it's often, who did you last meet at the ICC conference in Miami, or the LCIA meeting in London, or the ICA meeting in Dublin? So it really is necessary to build kind of a track record where you meet people through the IBA or through in the United States, the ITA. They have an annual conference in Dallas every June, well, except for COVID. And that conference, for those interested in oil and gas type cases, is the best in the world. It's without exception. If you become known in the Houston bar, you will get cases doing international oil and gas arbitrations. And so that's the first thing. The second thing is that, as I say, it's the chicken and the egg. You have to have done arbitrations before people will trust you to do arbitrations. And so what I recommend to people is to take on pro bono cases through institutions such as the BVI IAC, or in my jurisdiction, the what's now called VANIAC, the Vancouver International Arbitration Center. Volunteer to do cases pro bono for parties that are having a hard time getting into court, especially now with COVID, but can't afford the cost of a one or three person tribunal, and do those cases, or do things that through trade associations where they have, whether it's maritime arbitrations or securities arbitrations, where they have often consumer type arbitrations. Again, do those franchise disputes involving Subway to get some arbitrations under your belt. You just need that one or two or three or four or five cases that you can then dine out on and talk about, oh, well, when I was doing this case, and then you can say, yes, I have experience as an arbitrator. So those are the two pieces of advice I would give young people, and then associate with a mentorship program.
Thank you very much, Murray.
Yes, all very good advice. So now, Murray, we need to know, what does Murray Smith QC do for fun?
Well, I have no hesitation about that.
Okay.
What I do for fun is I go into the forest. Vancouver is blessed with miles and miles and miles of trails through forest, right in the heart of Vancouver. We have Stanley Park, which has miles of trails, and then we have the University of British Columbia endowment lands, which have miles of trails. And we have a rainforest here with massive cedar trees and hemlocks and Douglas firs. And you can walk for hours and you are suffused with a feeling of well-being. I'm convinced that those trees give off chemicals. And so when I'm in the forest, I'm happy. And so that's what I do for fun, and I do it every chance I get.
Nice.
And it's COVID friendly.
Say that again?
I'm sorry, and it's COVID friendly.
It's COVID.
Oh yeah.
Of course.
Very much so, yeah. Thank you, Murray.
We do have a bonus question.
Oh no.
Yeah, no, this is not hard. This is actually fun. Now, music is the international language, so a lot of us believe, and I think it is indeed. What is a song that you're listening to that you might consider like your theme song, maybe while walking through the forest?
I don't know. I have to confess that, and I don't want to sound like an old fuddy-duddy, but Strauss's Blue Danube Waltz is my favorite piece of music in the world. I recall when I did my camper van trip through Europe, driving up the mountains, highways of Switzerland, listening to Strauss. And yesterday, as I was driving through Vancouver, I was listening to Strauss on my car stereo. So I love those Strauss waltzes.
All right.
Okay, wow. I mean, they're beautiful indeed.
You know, you expected the Rolling Stones, but you got.
Yeah, definitely.
It's all
Very
good. It
much
sounds good.
Good.
Murray, I believe that's all we have time for today. I want to thank you so much for taking time out of your busy schedule to join us here on Arbitration Life.
It was my pleasure.
Yeah.
So fun to be with you. Thanks so much for inviting me. And I
Thank
hope
you,
to see you
Murray.
soon.
We hope to see you.
Yes,
absolutely.
Soon, I hope.
Yes.
In person in the BVI.
As soon as I can get on a plane.
Yes.
Sounds great.
Okay.
All right. All right.
Thank you so much, Murray.
Thanks so much.
Bye-bye.
Bye-bye.
Thank you, Murray Smith QC, for taking time out of your busy schedule to join us here on Arbitration Life.
Thank you, Murray. And for more Arbitration Life, please be sure to hit the subscribe button and to follow us on LinkedIn, Twitter, Instagram, and Facebook at Arbitration Life.